Right. So good evening, everybody, and a warm welcome to the CoE-IP and MSH webinar series session 3. Our topic for discussion today is that are computer-related inventions patentable in India? Decode CRIs. It is my honor to introduce our speaker for the day, Mr. Siddharth Sharma, Principal Associate, Rahul Chaudhary and Partners. Mr. Sharma has 9 years of rich experience in the fields of patents and is a registered Indian patent agent with a graduate degree in electronics and communication engineering. His principal work areas include drafting and prosecuting patent applications relating to various jurisdictions such as India, US, and EP. Additionally, he also represents clients in hearing matters before the Indian Patent Office and has also conducted several IP training and educational sessions for institutes, inventors, and in-house counsels, also having authored several articles on Indian patent law. Over to you, sir.
Thank you, Taina, for the wonderful introduction. And I would also like to thank CoE-IP and MeitY Startup Hub for presenting us with this wonderful opportunity to share our knowledge in the Sorry, am I audible?
Yes, that's very well.
Right. I'll also share the presentation slides and I'll just commence with the session then. I hope the screen is visible.
Yes,
the slides.
Yes, it is.
Perfect. So once again, I would like to thank CoE-IP and MeitY Startup Hub for giving Rahul Chaudhary and partners this wonderful opportunity to share our knowledge regarding computer-related inventions with all the startups, all the budding startups, the ecosystem that we are witnessing in today's time in this country is absolutely phenomenal and quite encouraging, to be honest. We see a lot of potential in all the technology developments that are occurring in the startup landscape, to be very honest, and a lot of it actually carries a lot of IP potential as well, and just that the right knowledge at the right time is required to be imparted to the startups, and this as I said is a wonderful initiative by the two entities. So beginning with this today's session. Just a quick introduction of the firm. Rahul Chaudhary and Partners was established in the year 1983, and collectively it has more than 37 years of experience in handling IP matters. The firm is headed by Mr. Rahul Chaudhary, who is one of the most respected and well-known litigators and legal advisors in the country. We have been handling IP matters for close to almost 4 decades now, as you can see. And we have also represented close to 100 out of the Fortune 5 Global 500 companies. And time and again, we have been guiding them in protecting their IP of various forms. And over the years, the journey has grown in a very staggered manner and quite exponentially also in the past, let's say 2 decades, I would like to say. And it has been a tremendous journey and a fruitful one, I would say. And along the course of the years, we have had some major role to play in some of these landmark judgments as well in certain trademark related domains and otherwise as well. So across these various IP verticals, we have been actively involved in guiding and helping our clients. For example, we have had the wonderful opportunity of
तुम्हारे ओके के लिए रुका था मैं.
Gaurav, can you mute all, please?
क्यों? मैंने तो उसको क्वेरीमल की मेल तो तुमको भी मार्क है ना. हाँ, ब्लैंक दिखा रहा है.
Ashish sir, can I request you to mute your mic, please?
Right.
Okay, go ahead, Siddharth. Sorry.
Right. Not a problem. So as I said, we have been dealing with IP services of all sorts to all our clients regarding patents, trademarks, copyrights, designs, IP enforcement, transactions, and allied type of services. And it has been our pleasure and honor to fulfill all the IP services and requirements and understand them in depth and to be able to guide the client to the best possible IP solutions, which often leads to, like an IP coverage which is beneficial for the client rather than just creating IP pool of something which is not eventually helpful for the client. But knowing and understanding the details of IP applications and kind of protection that that a client can go for is one of the key areas that we focus upon. So moving forward, our today's agenda is to basically decode the part of our computer related inventions patentable in India or not. Over the 9 years of my practice, I've more than like zillion times I've had the experience of dealing with clients coming from IT domain and several major clientele which deal in exclusively software related services and products. And I have had this question from a lot many clients that are computer related inventions or our computer programs or our software patentable in India or not. So we'll come to that answer. We'll decode that how to arrive at a patentable software solution or a patentable computer program. And to set the tone for the session, I would first just quickly run through what are the types of intellectual property protections available and what exactly are the criteria for patentability. And then something which I call as a Lego approach towards software patenting. It's a very block by block approach, which will help our startups today to identify that whatever they are working on or whatever potentially that they are creating, is it patentable or not, especially in terms of computer programs and softwares. Then we'll also look at what our Indian Patent Act talks about, or like what is the law relating to the patentability of computer programs in India, and what sort of guidelines are there for the examination of computer related inventions in India. And we'll also touch upon the topics of patenting of AI technologies and how are CIRI inventions in other jurisdictions treated and looked upon. And to conclude, we will head towards the landmark cases and some of the examples of software patents which are there presently in India today and in patented. And finally, we'll have some key pointers to note and carry forward with us, which would enable us to identify such applications and such potential softwares which can be patented. So to begin with, just a quick roundup. Intellectual property is nothing but creation of the human mind, and it could be of several types. For example, it could be a logo or it could be a slogan. I mean, we all are familiar with the logo of Nike and the tagline, just do it. So such form of creations, such form of intellectual creations are often protected under the trademark form of IP protection. Likewise, if you are writing a poem or you're author of a novel, or if you have some artistic work, or if you're writing a code, a source code or an object code. So all of this literary work, artistic work, they happen to fall broadly under the category of copyright protection. Likewise, moving on to the patent type of IP protection, patents are usually granted for new processes, products, machines which are not existing prior to the date of your invention. And the patent office has a whole examination technique, and we'll not go deep into that right now. Later on in the session, we'll touch upon that as well. And similarly, the aesthetics of any product that you have designed, let's say you've designed a cap or a bottle or a geometry box or anything for that matter. So the design or the aesthetic side of your intellectual creation is protected under the umbrella of designs. And coming to the trade secret part of things, so many a times organizations do maintain some internal processes or some internal testing mechanisms of software, or let's say the Coca-Cola secret, the secret to what formulates the Coca-Cola in the recipe for Coca-Cola is still today a trade secret. So such things fall under the category of confidential information, such as processes, formulas, internal testing softwares, and whatnot. And they're often kept as trade secret in some cases in which the company finds benefit to not disclose them. So these are generally the broad category, and our focus today is going to be on the patent side of things. That if you literally have a code in your hand, if you have a computer program, if you have developed a software, if or not you can go for a patent protection on it. So that is what we are trying to uncover in today's session. So coming to the criteria for patentability, that how exactly is patent office, going to evaluate your invention, or how the patent office is going to look at your software. Uh, so there are some fundamental criteria that you have to fulfill in order to be able to get a patent grant from the Indian Patent Office. So the natural process involves that once you believe that you have an invention with you, uh, you have to apply for an application to the Indian Patent Office along with certain requirements of that application. Now, in the examination, the Patent Office evaluates the application on these criteria. It says that your invention should be novel. That is, it should not be existing prior to your application date beforehand. It shouldn't be the case that whatever you're trying to apply for a patent is already, existing in, let's say, US or Australia or Europe, and you're just now applying for it in India. So it shouldn't be exactly already available in the market or known in the market. And likewise, any invention for which you apply for a patent, it should not be it should be non-obvious. That is, it shouldn't be apparently visible that you combine A plus B to arrive at your invention. As an example, I would say that if I'm sending out email communication, and let's assume that I want to enhance the security of my email communication. So the natural solution which comes to my mind is to probably apply some cryptographic technique of encrypting the messages in the email. So now if I take this very obvious approach and go to the patent office that I want a patent for this method of sending out cryptic emails, so it's a very obvious approach that even I knew as a layman. So patent office checks for this criteria as well, that whatever you're claiming to be your invention, it should not be obvious to a person who is coming from that same technology field. Likewise, whatever you create or claim to be your invention, it should have some industrial applicability as well. It shouldn't be the case that you're claiming anything and everything, but it should find use in the industry, because the ultimate aim for grant of a patent is also to benefit the society at large or economy at large. And hence the industrial applicability is also important. That is where the development of science and economy and the benefit of mankind will go hand in hand. So that is why one of the criterias for an invention is that it has to have some industrial applicability as well. Now comes the main important part from where we'll develop on today's concept, that your invention should also be patent eligible. Now, under the Indian patent law, there are several categories of inventions which have been declared to be non-patentable. You cannot get a patent for that because they are barred from patent protection. So the dilemma or the conundrum with respect to computer programs and algorithm starts coming from this point onwards, that if or like when you have a software in your hand or when you have a computer program available with you, if you are working on a in an IT field, and if you're trying to solve the challenge of some, let's say, database access, or securing the transactions between end users, so naturally you're bound to get down to the coding side of things. And when you're formulating or developing or creating such intellectual properties, such intellectual solutions, now comes the question of, are they actually patent eligible? So moving on to this, there is a Lego approach, which I believe is a block by block Lego, as we all know, with the blocks and how we simply align them to form shapes. And likewise, if you happen to evaluate your intellectual creation, you can do a step by step check as to identify that is your invention carrying the potential uh, to be able to qualify for patenting, for is it actually patent eligible or not, right? So naturally in the development of a software cycle, the very first step starts with identifying the requirement in any given process which is out there. And once the requirement of a process is understood, the natural next step is to create an algorithm for fulfilling the requirement. Algorithm simply is a, let's say, it's kind of a blueprint which leads you to the solution or completion or fulfillment of that requirement. And subsequently, in the next step, you write the computer program based on your algorithm to have, you know, to actually execute it later on for the completion. Or, hello? Yeah. So after having the computer program in place, you load it onto a memory which is executed by a processor of a machine, for example, a desktop or a workstation or a laptop or a mobile, even let's say in the case of mobile applications. And eventually you get into the testing phase, and later on once everything is in place, the desired effect is produced, that is the requirement is fulfilled for which you were trying to create the software in the first place. Now to have or to go with the block by block approach, you have to formulate or you have to ask yourself certain questions during this whole cycle. That let's say at the very first phase, you have to identify that whatever process you're working on or whatever the requirement or the problem area relates to in any given process. Let's take the example of email communication only, right? So we have to dive deep into the process and see that is it a technical process. And for the email example case, I would say yes, because it involves the use of two end workstations or two end user devices. And it is sending out email communication over radio technology, over broadband technology between the two devices. So is sending email a technical process? The actual email is sent via a technical process. And the next question that you have to, or the next criteria that you should check internally is if a machine-based implementation is there for your process or not. Again, coming to the case of email communication, it's a machine-based implementation. We naturally use user devices such as laptops or mobile devices to send out the emails. And next, the desired effect, if whichever desired effect is produced, that is in my example, I wanted to ensure security of the email. So hence I was using the cryptographic technique for encrypting the content of my emails. So does it bring any technical advancement is the third question that you have to assess. So uh, once you have the answers as yes to all these questions, that it's a technical process, yes, it's a machine based implementation, yes, and does it bring any technical advancement, yes. So that means it has satisfied the basic criteria of eligibility, that your software or your computer program is patent eligible. Now the other criteria remains as it is, that I told you about a couple of slides back, that once it is patent eligible, the patent office also independently has to check if it was novel or inventive or not. So as I told you earlier, in my case, the email one was not inventive, because it was quite obvious for a person to combine cryptography into emails to enhance the security of emails. So that would have eventually not led to my patent grant. But from the eligibility perspective, it is very much eligible to get a patent grant, subject to I fulfill the other criteria as well. So finally, concluding the Lego approach, in very simple terms, for any software or any computer program that has a technical implementation, that provides a technical solution to a technical problem, and something which produces a technical effect, is patent eligible. Now, many a times on the internet and when consulting with the IPR professionals, you must have heard the very basic term that computer program in combination with hardware is patentable. So what it effectively means, uh, in the most literal sense, it means that your computer program as a written code is not eligible for patent protection, and in such cases, if you want, you can go for copyright protection for the literal reproduction of the code. Under the copyright protection, your code would be protected from replication or duplication. If tomorrow some other party is duplicating and using your computer code exactly in the same fashion, then they are liable under copyright infringement. But however, as I said, it's only the literal form which is protected under copyright, and the functionality achieved uh, via your computer program, the technical problem that you solved, the technical effect you brought about, it's only but natural that the coding could be done using some other code, or the piece of software code could be rewritten using some different parameters or some different routines, so that it is not an exact replica. So in such cases, a potential infringer can easily, design around or circumvent around your original intellectual creation. That is why uh, it becomes very important to have the computer program in place. That's excellent, but you also need to go for a patent protection subject to the fulfillment of these criteria, that if your software or if your computer program, it has a technical implementation, it provides a technical solution to a technical problem, which eventually leads to a technical effect, then it is patent eligible. You should definitely apply for a patent for your software or your computer program, because what it does is your patent protects the functional side of things. You need not then in tomorrow's date worry about the literal copying of the code. Even if somebody is, copying the functionality achieved by the execution of your code, even in that case, that person would be then liable for patent infringement, and you can obviously seek damages and get into licensing terms and whatnot. So moving forward, what exactly is this technical effect? Speaking of the computer domain, some examples were issued in one of the previous guidelines by the patent office in, I think, back in the year 2013. So over there, they cited some of the examples as, if your software or if your computer program leads to a higher speed or higher, speed of calculation of, or higher computational speed of the computing device, or if it results in reduced hard disk access time, more economical use of memory, or if it results in more effective data compression techniques. We also have one of the case laws later on this. And if it also results in an improved control, let's say if you have most of development in today is heading towards the drone side of things, and Amazon sooner than later they would, it's 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 presumed that they would move towards delivery of your parcels or whatever shipment that you have ordered through drones. And so clearly robotics is an upcoming field, and any improvement in the accuracy of the robot, for example, improvement in the control of the robotic arm, or improvement in reception transmission of radio signals. I mean, we all struggle with the bad signals in today's date, or when we are in a moving cab or a moving vehicle, and if we are on calls, then we often see that there are some call drops happening. So any improvement which solves that issue, and which improves the reception or transmission of radio signals, and so such things count as technical effect, speaking from the computer side of things. Now moving on to what exactly, as I said earlier, that there are certain category of inventions which are not considered or not treated as inventions under the law, under the Indian patent law. So to help you familiarize with what exactly the law is, Section 3 of the Indian Patent Act of 1970, it defines, there's a huge list of inventions which are not actually treated as inventions, or what are not inventions. So amongst the various subsection, the one relating to computer programs is subsection K. Subsection K of section 3 says that any mathematical or business method or a computer program per se or algorithms, they are not inventions. So the law does not recognize them as inventions. Now, you must be wondering that all this while I have been telling you or educating you about, how you can identify patent eligible matter, whereas the law strictly says that computer program purses or algorithms are not patentable. So over here, we have to focus on the part, the term computer program per se. Per se means as such or in its literal form. So over the development of jurisprudence, this term per se was proposed by the parliamentary committee to be included in the law, so that genuine inventions which are there as a result of computer program should not be precluded from patentability. That is why this term per se, computer program per se, was included into the statute, and that is what helps us in distinguishing our patentable software inventions from what exactly are literal computer programs per se. So as a cheat to this computer programs per se, that is where if I go back a couple of slides where I told you that the literal computer program, as long as we are not claiming, or the subject of our patent is not literally just a computer program, but we show that we have a tangible implementation of that computer program in that hardware, which produces which satisfies the above criteria, is eligible for patent protection. So consider the case of that email application. Let's assume for a second that nobody had done the cryptographic emails before. So just pondering over it for a while. Now, suppose I put in a patent application to the patent office, and I simply say that what I have is a sequence of steps, which is algorithms, or if I just have a computer program which will take the email content as input. It will encrypt it using, let's say, an encryption algorithm, and it will give you an output of encrypted content for emails. Now, effectively, if I just leave my patent application at this level, it's more or less just I'm simply defining a sequence of steps. That is where I have to focus more on the hardware side of things. I have to, besides just the algorithm, or the flow chart or the sequence of steps, I also have to introduce the environment, the computer environment, or showcase the devices and the challenges, the security issues which were there, and then present it as a problem, as a technical problem, and showcase this as a technical solution occurring between two user devices who are eventually going to send email communication to each other. So that is where the role of computer program plus hardware comes into picture. To to help the patent examiners at the patent office, the IPO issued some guidelines for examination of CRIs in India. And while it helps them, it also gives us some opportunity and clarity into what exactly is patentable, and amongst these excluded subject matter of 3K, what cannot be patented and what can be patented. So one of the very key features of these guidelines was that the focus of the examination should be on the underlying substance and not on the particular form in which the invention is claimed. So what this literally means is that many a times the patent office comes back to us and says that okay, whatever you have just try to put in as claims in your patent applications, it is nothing but just a sequence of steps, and therefore they object it under 3K. They put in the objection that it is nothing but an algorithm. However, my I know for a fact that my process was of email communication, secure email communication occurring between two computer devices, and I enhanced the security of my confidential data, and nobody can easily snoop in or hack my email and get the contents. So the underlying substance of my invention was to solve a challenge, to solve a problem, and the patent office should not literally see it as just a sequence of steps. Rather, the focus should be on the underlying substance of what I'm trying to claim as a patent, and not just the form of what I'm trying to claim in the patent application. Just to give you some quick examples, with respect to mathematical methods, so the field of areas such as encoding, decoding, or reduction in noise in signals. So, for example, in the case of encoder with improved encoding efficiencies, these can be considered to be patentable because effectively the actual application area is, it's a practical application area. Whereas if you simply have some method of calculation or some equation for selecting, let's say, products or any random numbers, or finding square roots, or some process which is completely mathematical in nature end to end. So in such cases, it's quite difficult, I would say, to present your parent application as patent eligible. So something like, let's say, a method of calculating height of a building is probably excluded from patentability, just sheerly for the reason that it is directed towards a mathematical method of calculation of heights of a given object. Whereas in the other cases, in the above cases, you will notice that there is a clear practical implementation side of things, which improves the technology per se. Now, coming to the business methods, if claims as a whole, they solve a technical problem in business domain. So one should not be completely averse to patents just because they are in the business side of things. If they are developing new technologies in the business side of things, you should still get down to evaluating the patent eligibility of your invention, because let's take the example of a method of improving security of transactions. If you're somehow able to ensure security of transactions or increase their security, though your application area might be in the business side of things, but what you're trying to actually address is a technical problem or a technical challenge associated with the security of transactions, and you are able to solve that challenge. So hence, despite the broader area or domain being business domain, you can still get a patent protection in this area. A negative example, on the other hand, would be if the subject matter is completely about the business or trade or financial side of things, that let's say a method of identifying and selling stocks. In such a case, it would be most likely be seen by the patent office as patent ineligible subject matter. Now, coming to the computer program per se side of things, when the execution of we are going to if referring back to the slides discussed earlier, when the execution of computer program, it provides a technical solution to a technical problem. So in such cases, the end result is treated to be patent eligible. And in the negative side of thing, if the subject matter is directed to computer program, then the set of instructions or routines or subroutines, in such cases, they are usually objected to by the patent office, and the patent office as a blanket treats them as something which is not patent eligible. So for example, a method of displaying alerts related to a task. So that is something which which the patent office might simply see as something which is entirely done by the software within the computer, and not improving the computer speed or the computer efficiency or any tangible effect which is there. So similarly for algorithms, when the sequence of steps are there, and if they relate to a technical process, as in the case of an email communication example, and if it provides a technical solution to a technical problem, for example, a method of compression of data, or a method of encryption of data to be sent over a network, such cases, such algorithms relating to technical processes are considered as patent eligible. Whereas some example like a method of naming documents, which is a sequence of steps which would not result, or which does not relate to a technical process and does not solve any technical problem. In such instances, these algorithms would not be treated as patent eligible by the patent office. Coming to the subject of patenting AI technologies, so In the past couple of years, various jurisdictions, Europe is there, US and Japan, they have released guidelines, examples in their guidelines to what exactly the examination of AI related invention should be done like, and they have sought public comments onto these subjects. So largely, AI technology inventions are treated under two categories. One which directly is targeted towards improving the AI technology, and one which is focused on the application of AI in a certain domain, in a certain practical domain. And these under these two categories, all these jurisdictions are currently looking at and evaluating the inventions to see what exactly is patentable or not patentable. But the Indian Patent Office, they are yet to release any particular guidelines relating to the examination of AI inventions or any example of patentable AI inventions. Any sort of comment from the Indian Patent Office is yet to be released. But as we'll also see later that the Indian Patent Office is much closer in practice to the European Patent Office, and European Patent Office has identified AI as a branch of computer science, and therefore they treat them as computer-related inventions. So in most likely in all scenarios, when an invention is based on AI technology or is directly targeted at AI technology, uh, the valuation in Europe, in other jurisdiction, and in India is likely to be similar to that of computer related inventions only. So therefore, if you're actively working in the field of AI technologies, you should definitely consider securing patents for your technology. You should see what kind of problems and solutions are there, which is brought about by the application area of your AI technologies. And there is currently no blanket statement as to the validity of these patents, but going by the trend over the years, over the decades, it is mostly to be on the positive side of things and AI technologies. In fact, I have included one of the examples later down in the slides, which talks about the implementation of AI technologies, and the patent has been granted by the Indian Patent Office. So we see a positive trend along the patenting of AI technologies in India for sure. As I said, the patent laws are in a sense universally they are in harmony. It's not that one of the jurisdiction is going to hold a completely stuck position to other jurisdiction, and therefore the criterias of what is patent eligible or what is not patent eligible is going to be more or less the same. It's just that how the examination is done in a particular jurisdiction, or what are the tests that the patent office applies for determining the fulfillment of that criteria. That is where the differences come into picture. So much of India's patent practice, as I just mentioned, they are aligned with that of the European jurisdiction. So EPO examines the CIIs in a similar fashion to that of India. That is, they also look for the implementation, the actual physical, tangible implementation of your computer program. That what exactly happens when a computer program is executed. Is it improving or solving any technical problem? Is it addressing a technical challenge? Is it causing improvement in the computer per se? And is it bringing about a technical effect? So in Europe, if the answer to all of that is yes, then your invention is pretty much patent eligible. US, with a slightly different language, they believe computer programs and algorithms as to be abstract ideas because of the non-tangible form in the literal sense. But if you have an invention filed in US, and if you can present your patent application in such a form that you're able to show that your computer program or your algorithm, it produces an effect that is significantly more than the abstract idea, then you have a patent eligible software or program with you. So as I said, for example, in improvement in computer technology, reduction in consumption of computational resources, speeding up of existing computer processes, all these are caused or done as a result of the computer programs, but in effect, they are improving the working of the computer machine which is there, or solving the challenges associated with the machines. And definitely, so such subject matter or such softwares are considered to be patent eligible. Now, moving towards the last segment of today's session, there are certain landmark cases. So this whole premise, this whole grounded legal footing that anything which has a technical contribution can be considered to be patentable was developed or witnessed as a flag post in these three cases. These three cases all reiterate the same position taken by the Indian judiciary. These three cases are coming from the Delhi High Court, and in each of the cases, the conclusion was the same, that if your invention, if it is resulting in a technical contribution, if it is solving a technical problem, then in that case, it is patent eligible. So in the Ericsson versus Intex case, Ericsson had a series of 8 patents relating to the 2G and 3G standards for which they they sued Intex for infringement, and Intex, as a countermeasure, they challenged the validity of the patents. They said that amongst the several grounds that they took, Intex challenged, saying that whatever Ericsson has in those 8 patents, they relate to computer program and nothing more than that. In the evaluation of the overall case, the Delhi High Court held that the invention which has a technical contribution or has a technical effect and is not merely a computer program per se, as alleged by defendant, that is Intex, and the same is patentable. So this set out the tone for the upcoming cases as well. For example, in the Ericsson versus Lava case, which was there, Ericsson had sued Lava. I apologize for the typo there. Ericsson had sued Lava in the Delhi High Court for infringement of, again, the same 8 patents. Ericsson had also brought a challenge to Lava as well, that Lava was also infringing on Ericsson's patents. And Lava also challenged in a separate suit the validity of the patents, but this time under algorithm, amongst other objections that they had to the patent. Even in this case, also, the Delhi High Court observed that the inventions which were a part or the subject matter of those 8 patents, they provide an efficient encoder that improves the synthesized speech quality. Now, this synthesized speech quality is something which was perceived as a tangible effect by the Delhi High Court, and they held that it's a tangible effect that can be perceived by humans, and therefore it is not abstract, because algorithm is simply just a sequence of steps. It's a sequence of abstract steps which has no real tangible form, but the improvement in speech quality is something which you can tangibly make out the difference in. So in its conclusion, the High Court said that it appears that these inventions, which have resulted in an improvement, or let's say technical advancement in telecommunication technologies, and have had a huge effect upon the manner in which they function, result in practical implementation and actual physical representation. It says mere mention of algorithm or mathematical formula in a patent document should not be inferred to mean that the invention is nothing but an algorithm. So clearly, this resonates with our teachings of this session, that you have to have a tangible effect which is resulting in a technical contribution or a technical advancement, such as in the case of speech quality, in the case of Ericsson versus Lava. Coming to our third case, Ferid Elani, I think he's a Tunisian citizen. He had filed a national based application in India long back. The subject matter of the patent application, it related to the web access of information sources and services over the web. And the patent office, in its evaluation, said that the claims of this patent was nothing but just computer program. You are simply accessing information sources over the internet, or services over the internet. So what exactly is new in this, or sorry, what exactly is patent eligible in this? They objected it to being just a computer program or algorithm. The same position was also confirmed by IPAP, that is the Intellectual Property Appellate Board. And Feridelani, after not getting a favorable outcome from the Indian Patent Office and the IPAB, he approached the Delhi High Court for a favorable resolution. The Delhi High Court reiterated the same position, but with a core reference to technologies of today, which gives a very promising outlook of how the law of 3K should be evaluated. Very precisely, the Delhi High Court gave the position that in today's digital world, when most inventions are based on computer programs, it would be retrograde to argue that all such inventions would be non-patentable. So innovations in the field of AI or blockchain technologies and other digital products would be based on computer programs. So this is a very good judgment which is there, and it clearly, showcases the stark difference or the retrograde approach to negating patent on just simply being computer programs. And this judgment clearly identifies that in today's date, all the devices, we live in an IoT world, and in a connected world, most of us would have seen Alexa or such home assistant products, which Wi-Fi lights are there, and you can switch on the AC, the lights and curtains and whatnot. It's a connected world out there today, and the underlying essence or the ground basis or the functioning of all these devices are done or governed by computer programs. So in effect, if you are making a contribution in the computer program of these devices, which help them perform better, so definitely a patent should be granted, or you should be eligible for patent protection, is what the court reiterated. So uh, coming to the conclusion part of this audit, the court said that the patent application in these fields would have to be examined to see if they result in a technical contribution. So reiterating the same position, for any software or any computer program, the challenge lies in showcasing that it has a technical contribution, that you are improving the devices or the process in some fashion. So that is the golden rule in cases of softwares. Just to see some cases, some of the recently granted cases of Indian patent granted by the Indian Patent Office. So the first one of them is related to the system and method to convert a mixed language conversation into text, and the next one is an artificially intelligent device and system for coaching of a batsman. So in the first patent, it relates to simply an audio conversation which is in mixed language, and how the software or the program is applied onto it to identify the different speakers in a separate manner, and eventually convert the audio input in the mixed language. It could be a mix of, let's say, Hindi and English, or mathematical numerals, and eventually you are able to convert it into a text. So this was an out and out computer program based invention, for which the Indian Patent Office considered it to be patent eligible and granted a patent to it. Likewise, in the other case, the subject matter of this patent dealt with the ball delivering machines, which integrated artificial intelligence technique for training the batsman. In the present case, um, the AI technique used to factor in the stance of the batsman, his position relative to the wickets, his previous playing styles, and factoring in all of that, identify its weakness and accordingly calculate where has to bowl to the batsman by the use of AI. So even this was found to be patent eligible by the patent office, and it also satisfied the other criteria, and eventually a patent was granted for this uh, this technology as well. So the key takeaways, just to quickly wind up or touch upon whatever we have considered till now, that we have to identify the type of process to which your software pertains. For example, is it a technical process, or is it a business process? Is it a financial transaction related process? Subsequently, we have to see that if the software is solving a technical problem in the realm of the identified process. So even if it relates to business process, you still have to see that if your software or computer program is relating to, or it is solving a technical problem. Next, you have to identify the technical contribution of the software, and accordingly, please excuse me. Yeah. So if a technical contribution is identified, then we can successfully say that our software is patent eligible. And lastly, you should always consult a patent attorney, because the law keeps on developing, and one should be, uh, be successfully guided, or I would say guided by a person who has the skill in both the technological areas and the legal areas, so as to eventually help secure you with a patent for all your efforts into the intellect that you have created. Lastly, I would like to thank you all for your attention, and I would like to throw open the floor for any comments or any questions that you might have.
Hi, great presentation. I just wanted to understand under what circumstances should we go for a provisional patent? What can be the advantages, and what's the cost, and what is the amount of timeline? How to go about a provisional patent? If you can touch upon that, please.
Yeah, sure. So a provisional patent application is filed for several reasons. The most important being that suppose if you have an imminent disclosure, public disclosure coming up, if you want to showcase your invention to potential investors, or if you have to display your product in an exhibition. So in such cases, you can quickly file for a provisional patent application. What it helps is, it helps you in securing the date of priority for your patent application. That means that after, let's say if you have filed a patent on 1st January 2021, you get 1 year's time to convert it into a complete application. And another benefit is, it all for certain cases, let's say we are at the prototype stage, but we haven't actually finalized the product till yet. Or so what we can do is, we can capture the key elements of our invention and put it into a provisional application, file for the provisional application, thereby securing the priority date of 1st January 2021. And then we have an year's time to us to convert it into a complete application. And because you have already secured your priority date, that is, anybody after that date, after your disclosure, after your discussion, filing for a patent application on similar subject matter, most likely would be denied patent, because you can always challenge the validity, because you had the priority for that. So that is essentially the purpose of provision. So in cases where you quickly want to secure the priority, or in cases where you have incomplete information as on today, but yet you want to go for quick securing of the priority date, in such cases you can go for filing of provisional applications. And coming to the fees part, the fees is only charged one time, and by the patent office, it's only charged one time. And at the time of filing of the complete application, you need not pay the fees for filing again, as long as you are within the upper limits of the number of pages or the number of claims which are permissible.
Thank you, Rahul. Just a follow-on question. When should we decide to file for a patent inside India or outside India, like a PCT patent? What can an Indian patent be converted into a follow-on global patent? How does that happen, whether it's country-wise or a PCT? You can touch upon from India to a global perspective.
Sure, sure. So, first of all, we have to understand that patents are territorial in nature. Patents offer protection only in the jurisdiction in which you apply for. So, suppose that email communication method that I have, if I implement that in India, and if I don't file for a patent in Sri Lanka, so people in Sri Lanka can easily and freely use my technology. Therefore, I have to ensure that I file the patent in each and every jurisdiction or geographic location in which I have interest to secure my technology. And let's say so a proper business case in this sense would be to first evaluate that where exactly your competitors or your most likely infringers are to exist, and that is when you decide on the countries where you want to file. Taking referring to one of the personal episodes that I had, this one particular inventor had identified the need for, it was also a business patent, business software patent, which related to producing of charts from the raw unstructured data of Excel sheets. So this fellow was very keen on only and only filing patent protection in India and in US, and not in Europe, not in Australia, because he had identified that a large chunk of competitors for his technology are there in US only, and India as well, and he did not consider other jurisdiction. And that is how you have to plan your route from India to outside India. And again, when you want to go from India to outside India, as I said, you have to file in each jurisdiction, but there are two ways to go about it. One is that you directly file in each of those countries directly, and one way is that you file for a PCT application. And once you have the PCT application in place, it gives you an enhanced timeline. It gives you a total period of 31 months from the date of first filing in India, let's say. It gives you a period of 31 months. And in those 31 months, you can further evaluate, wait for further funding, and then also decide on the jurisdiction, and eventually file in all those jurisdictions which are of your interests.
I had a question. Like, let's take this AI, recommendation for improving the batsman, the cricket performance. Let's take that. So there are different ways to do that. AI is one way, and there are only certain sensors. Like you can use the camera, you can use mics and all those sensors. So there's a limited number of ways in which you can limited number of sensor which you can use to actually see like how a bowler or a batsman is performing, and it's how you deal with the data and useful information, how you get out of it, that matters.
Right.
So
Right.
let's say I bring about another algorithm, but it's an AI algorithm. I don't use CNN, I use some other network of my own, or let's say some other network that is available, and it improves the performance. It gives better recommendation. So will that be applicable for patent just because it improves? But application will be the same. It takes the sensor, it makes the predictions.
Right. So to begin with, it would certainly be patent eligible because you are actually claiming the practical implementation side of things by, let's say, working upon a new or a different AI technique for achieving, the training of the batsman, right? So patent eligibility most likely would be there. The patent office would agree to that part. But how novel or how inventive your eventual invention turns out to be, it is all dependent upon the available technology as on the date when you made that application, that how obvious it was for a person to combine. Let's say, as I explained, that in my case of email communication plus cryptography, it is very obvious that if I'm looking to enhance the security of my email, that I would naturally go towards cryptographic solutions. So likewise in your case, if the use of an enhanced AI technique to improve the efficiency of the bowling machine, if it was very apparent to a person coming from that technological field, so in such case, quite likely it could be that the patent office might consider it as uh, consider it to be an obvious combination of another technique, integrating into the existing art and arriving at a new system. So in such cases, the inventive merits could be a challenge.
Sure. Thank you.
Thank you.
So, Mr. Sharma, we have two more questions. If
Sure.
you'll be kind enough to answer them as well.
Absolutely.
So the query that has come in, that a business rule can be written to achieve an objective, but at the same time, AI can replace the same rule-based program. So in that case, a technical improvement is obvious in terms of processing time. In this case, can it be patented?
I can see it's there in the comment section, right? Yeah, just
Yes.
allow me 1 second.
Yes.
Right. As far as I understand your question, that certain business rule is there, and an AI-based implementation of the same rule, uh, or let's say a machine-based implementation at a very broader level. Effectively, you are implementing that business rule. Let's take it from the literal sense. It's a business rule. Let's assume that we are talking about a demographic location where the consumption of tea or coffee is a lot, right? So now my business rule on papers would be to identify, let's say, the people of a certain age group who are consuming the tea or coffee to the maximum extent. It's a business rule that I have certain business rules that I'll collect the data of sales. I'll sort them in some order, and I'll apply certain formulas to it. And naturally, the end structured data that will be there in front of me would give me a clearer picture of uh, which age group is in that given demographic location is consuming a lot of coffee or a lot of tea. So now if I bring AI into picture, and if I set these same rules, and if I train my AI model to execute the same rule, uh, the underlying bottom technology or the underlying bottom objective doesn't change. You're still trying to identify that who all are, which in which demographic area, what is the age group which is consuming maximum tea or coffee. So the process might be quicker by implementation of AI or any other computer program for that matter, to a different extent, obviously. But when we try to correlate it to the problem which we were originally targeting to solve, the problem was still to identify age groups in a demographic location who are consuming tea or coffee to the maximum extent. So in effect, you're right that the technical improvement will be there, but it would still be relating to the problem of business side of things. I hope that brings some clarity.
Right. Thank you, Mr. Sharma. The
And
next
I
is from
think,
Mr. Prasad, as you can see on your screen as well.
right. Google Play Store are produced by the inventor. Is application similar to others in the So applications such as Arogya Setu application, are they patentable in India, and how the application in Google Play Store are protected by the inventor? As I said, the application, the literal computer application form of things is something as a product or service that you are, rolling out in the market. And in such cases, it is essential to cover the functionality. Now, Arogya Setu is uh, effectively limited to linking of Aadhaar and registration of COVID and information of COVID in your area. So if you see the challenge being solved by the Arogya Setu application, it is more or less making you aware of the potential hazards in your vicinity. But I doubt an application like Arogya Setu would be patent eligible. In that case, my advice to you would be to go for a copyright protection. I see one more question which is
Right.
there, that can services like
Right.
software, hardware testing, or training can be patented? They can be definitely filed a patent for, but there comes one challenge. See, if your overall testing is resulting in reducing the man hours, or quickly identifying the challenges, or in such cases, you can probably target to file a patent, but it would be sternly examined by the Indian Patent Office. But I'll tell you one more challenge associated with the testing side of things. In most cases, most often than not, such solutions, I have seen them to be very in-house and internal to the company's practice. So in such cases, not having the knowledge of competitors, that how they are performing their in-house testing, could be a challenge for you to identify potential infringers. So one should also focus on, when seeking anything for patentability, you should also focus on how efficiently you can also detect potential infringers out there in the market.
Yes, thank you. Thank you for this insight. Could we take one more, please? Can
Yeah,
circuit
sure.
design be patented, and how do you ensure it has not been copied? Just to
Okay.
make sure this is the last question we'll be
Yeah.
entertaining.
Okay, so circuit designs as such, again, under the ambit of Section 3, the topography of circuits are not patent eligible. They, of course, have a different form of IP protection. You can file for protection of the topography of integrated circuits. There's a separate act for that. And under that, you can apply for protection of circuit designs.
Right, right. Thank you. Thank you, sir, for answering all the queries and also for an enriching and insightful session.
Thank you, Taina.
Thank you very much. I now invite Mr. Parimal Khare, Senior Project Manager, CDAC Pune, for his closing remarks. Over to you, sir.
Thank you, Taina. And thank you, Taina, and thank you, Siddharth, for a wonderful talk. There has been always a confusion about whether patenting software in India is possible or not. Rather, in fact, many without much information file as a copyright without knowing whether their invention is eligible for patent or not. I guess many of these such questions must have been addressed, or at least some clarity must have must have got by these participants. So thank you, Siddharth, for addressing many such questions we had. And I just wanted to inform everyone that CoE-IP is not only looking forward to host such kind of a workshop, but CoE-IP has a major role to play after these events, because the Center of Excellence in IPR is there to support all the innovators and startups and R&D organization to support their invention by doing undertaking the prior art search, or even the landscape report for various technology which are happening currently. And all these services has been provided free of cost to all the fraternity, mostly focusing into ICT and electronics domain. And I guess many of must have already visited on ICTF and IPR. If you have not, then please do visit, because we are looking forward, as I said, not only from the prior art search, but we are looking forward to host many of the landscape reports, which will help to identify the trajectory of the current technology development happening, not only in India but outside the world. And such kind of reports basically will give you a snapshot and overview of the patents in a specific subject or area, and covering the technology. We believe that such kind of a report will also help, filling up the critical gaps in the hyper competitive and high tech marketplace. So such kind of a services has been provided by the center, and I think this can be very well be utilized by many of you. Apart from that, I can also assure you that in near future we are looking forward not only providing the IPR related services, but also embark upon the processes of transforming the entire innovation and technology initiatives to help commercialize the research outcome, as well as provide the unbiased opinion on the radically changing technology paradigms. So please do connect with the Center of Excellence. We'll be conducting many more such kind of activities and events, which will help definitely in your course. So to conclude, these webinars is another conscious effort on CoE-IP's part to bring together the startup and R&D community on a single platform to help for establishing a connection for many meaningful partnership and stronger engagement. And believe me, the Center of Excellence is available there to support and to help you out, at least for the right guidance, the right directions. And even if you have any kind of questions or queries, where should we go, whom should we contact, how we can look for commercialize of this situation, connecting to the, even for the attorneys, like connecting to Siddharth and all, because all these good attorneys are connected with CoE-IP, and with the help of these attorneys, you also can look forward to file your IPR and exploit it commercially. So thank you very much from CoE-IP, and looking forward to have you guys in a continued sessions of IPR webinar. Thank you. Over to you, Taina.
Thank you, Parimal sir. Your insights are always valuable for us and the team. On a concluding note, I offer heartfelt gratitude again to our speaker, Mr. Siddharth Sharma. My gratitude to all the participants who've taken out their valuable time today. I conclude with our motto: build your IP, build your country. Please don't forget to follow CoE-IP and MSH on all our respective social media handles. Thank you, everybody. Have a wonderful day ahead and even better weekend. Thank you.